Okay, we're on the record now on CL 20-4259-I. And that's Susana de la Rosa versus Fernanda Quintanilla and BBVA Compass Bank. And just announcements for the record as to representation, please, one at a time.
Villalobos for Susana de la Rosa.
Keith Livesay and Juan Molina for Fernanda Quintanilla.
Christina Cunningham for BBVA USA, formerly known as BBVA Compass.
Okay, Mr. Livesay, were you saying something else, sir?
No, that I'm present with Mr. Juan Molina as representing the defendant, Fernanda Quintanilla.
Okay. All right, and Mr. Villalobos, you wanted to start with your motion to transfer?
I would prefer, Judge.
Go ahead.
Okay, Judge. On this matter, it was a matter of a case that Mr. De La Rosa passed away, and there was about $300,000 in a bank account. Last year, Mr. De La Rosa passed away, but he had gotten divorced in 2012. In 2012, he was married to Ms. De La Rosa, which is now Ms. Quintanilla. At that certain point in time, they got divorced and each took their accounts and everything. And we're not in dispute anymore that it was his account. It's been in the Court of Appeals. They've admitted it and everything. So now the issue, 2 years later, Mr. De La Rosa started putting money in the bank account. And there was no control, no anything. Mr. De La Rosa died, and then the heirs, it's in probate right now. The will provided for 2 heirs and 2 were excluded. When they met and found out that they were excluded, they go and tell Ms. Quintanilla that the bank account probably still has her name. Ms. Quintanilla, 4 or 5 years later, goes to the bank account and draws the money. We filed, because we didn't know what was going on yet, so we filed a TRO in this court. Actually, it was County Court 1 first. Subsequent to that, we filed a TRO. The judge ruled to keep the money in there because we were trying to keep the money, but she had already pulled $275,000 out. So the judge ruled for $25,000. Unfortunately, when he did that, he based it on argument, not on evidence. Ultimately, it would have been the right decision, but he did not allow us to present evidence. So probate was opened up and we filed a TRO for the $275,000, and that is pending right now. The Court of Appeals, Mr. Livesay filed an appeal stating that there was no evidence, and we agreed because there wasn't. The judge didn't let us put it in, even though it was the right decision. There was no evidence. So the Court of Appeals sent it back, and that's why we're here. But anyway, she had never had control. She never anything. But now the big part of this case, which is exactly the same issue, the same cash, the same checking accounts, the same bank accounts, is what the probate court has, $275,000, and of course, County Court 9 has $25,000. So we're saying that this case should be transferred. The probate court, as the court knows, has jurisdiction over anything that is probatable or it can be probatable or if there's an issue. That's why we're asking this court to transfer it to County Court 3.
Okay, Mr. Livesay, do you want to respond, or Mr. Molina?
Apologize, Your Honor. I will respond to this one, and Mr. Molina will be responsible for responding for most, for the other motions, except that he may need to chime in. What Mr. Villalobos just said was wrong. And let's start with, he's saying that everything is probate, the probate court has every jurisdiction over everything that's probatable. Well, that's not true. The court looks at our response. Well, first of all, we start from the premise that a probate court is a court of limited jurisdiction and it has to be specially authorized to hear the particular kind of case. And I've listed out in our response in Texas Estates Code 31.001 what the probate court is authorized to do. And if the court looks at it, it doesn't have POD accounts. They're just flat out not listed. And do you want to know why? Because POD accounts are non-probate assets. The state's code specifically states that a POD account is going to go by the terms of the account and it doesn't go through probate. So the probate court does not possess any jurisdiction over this matter because it involves a POD account. Furthermore, this isn't a situation where the administrator of the estate, who is Mr. Villalobos, is trying to recover the money. It's an heir saying, I know better than what the POD account terms state. And so I want to circumvent or rewrite the POD account. So again, that the probate court doesn't have any jurisdiction over this matter. Third, even if you could theoretically come up with jurisdiction, they've invoked the jurisdiction of this court. And it just is form shopping, Your Honor, that they didn't like what Court 1 did. They said, oh, well, we should have gotten it over everything. So that's why they go running into the probate court. And Texas has a policy against form shopping. And so by transferring the case, the court is rewarding the plaintiff for having invoked the jurisdiction of this court, losing, and then deciding he wants to pick up its marbles and play someplace else. Furthermore, Your Honor, I don't know that there's authority for this court to transfer to the probate court. There is a procedure for the probate court to drag or pull a case in. But Mr. Villalobos hasn't done that. He's had since January of this year to try to get the probate court to transfer the case. But he hasn't done that, probably because he knows that the probate court doesn't have jurisdiction. And then another thing I would point out, I guess lastly on this point, is that I do think that the issues are going to be somewhat different. And also the probate court is overloaded. I do some work. There's a affidavit of heirship that I was recently handling, and it takes 6 months to get a hearing in there, mainly because the probate court is overloaded. It's got, all the new COVID death cases that have come about. And so again, the way this case is going, it's not going to get resolved to 2050. And, we need, resolution quicker before, instead of that, everybody involved here, has passed away. So we were requesting that the court, and this court has already invested time. Court 1 was before Court 1 invested time. And so we're requesting that this court, and it's ready to go now, we're requesting that this court retain jurisdiction.
Okay, Mr. Molina, did you want to add anything? You're on mute, sir.
Judge, can you hear me?
No, Judge.
Yes, Mr. Molina's gonna add.
Oh.
Yes, Mr. Molina, go ahead.
Okay. And let's take a couple of steps back, Judge. Part of why commerce works, including banking commerce, internationally, nationally, statewide, and locally, is people rely on documents that are legislatively mandated. People rely on forms day in, day out. It's just an effective way of doing business, especially in this COVID era, Judge. Every week we run into folks who say, how can I get money quicker to my heirs if I pass? So every week we talk about, look, check your checkings, your savings, your retirement, non-probate assets, and make sure that you've designated the person that you want. And so this is referred to as the poor person's will. And so the reason why that's important is because banks want certainty, consumers want certainty, and otherwise you have chaos. You have people who don't know what to do. They've got $5,000, $2,000, and it's just not effective. In this particular case, it's a higher dollar amount. But what you're doing as a court is you're allowing uncertainty when something is so basic as a payable on death account. That's why we as attorneys, that's why financial advisors, that's why banks explain to folks. And in this particular case, again, this is a simple case. This is not a case that involves a young girl, gold digger, somebody 50 years older. This is not a case that involves somebody putting a gun to somebody's head. This is not a case that involves somebody in a hospital bed being hoodwinked by somebody. This is a case that involves a woman who was in love, and they were still in love since as I said the last time, the Selena era. They worked together, they lived together. Yes, they were married. Yes, they were divorced. Yes, they were married. Yes, they were divorced. Guess what? That's life in the modern world. Ray, the decedent, had access to knowledge because he worked as a general manager for H&H as a human relations person, human personnel. He had thousands of employees for decades and decades, and then he went out in business. He never changed this account for one simple reason: he didn't want to. That's it, Judge. This is a very, very simple case. The problem with rulings that disrupt commerce is you have uncertainty. Then even folks at the low end who have $2,000, $5,000, $500, it may not mean much, but it's all they got. And all they simply want to do is avoid us. They don't want lawyers deciding their fate. They want to circumvent probate. Why? Families got to eat. People have to go on with their lives. Probate court, unfortunately, these days, and I'm not faulting the judge, 3,500 people have died just recently in Hidalgo County. And so it's just inundated. That's why when Mr. Villalobos filed this case in Judge Gonzalez, we thought, okay, we'll get a quick hearing, which we did, but he didn't like the result. And so that's when he went back to probate court. In a nutshell, Judge, that's what we're dealing with.
Okay, Ms. Cunningham, before I hear a reply from Mr. Villalobos, did you want to add anything on behalf of your client?
Your Honor, all I would say is that looking at the document, either Ms. Quintanilla is a joint owner of the account, or if she's not, it is a PODO account. The payable on death designation is checked, and there is a beneficiary listed that is not the plaintiff. So either way, this is a non-probate asset.
Mr. Villalobos, you wanted to give a reply?
Okay, I love the fact that she says, they keep on saying that she receives because it's payable upon death. She is not the beneficiary. And we know she's also not the owner. So and that's why we filed the TRO. But the reason we're in the probate court is because they pulled the other 275,000 before we could put the TRO. So the probate court also did a TRO, and it's in the Court of Appeals. Now, when they say I didn't like the ruling in the court on County Court 1, I most certainly did. He granted it. However, they had already pulled the other money, so we could only hold 25,000. So I'm just so glad that they said exactly what we've been arguing. She does not take as a payable upon death beneficiary. And in all their briefings and judicially, even in testimony, we know that she is not an owner anymore because of the divorce in 2012. She had no control. Judge, I divorced him. The reason I'm in the probate, the reason I'm an executor is that he was a good friend of mine. And believe me, there was no love there. Otherwise, he would put her in the well. So that's the reason, that's what's going on. That's the reason that the probate court rules on the 275. Now, should later on they say it's not probatable, it gets kicked out. But in the probate court, because right now this court has jurisdiction over 25,000, and the probate court has jurisdiction over either 175 or 125 or 275. And Judge, I apologize because I just crossed over from Mexico and I don't even have a file. But that's exactly what's going on. We love the rulings in County Court 1, but we also knew that we just presented arguments. Okay, so and it's very important to understand the judge when he ruled, hey, you know what? I'm gonna hold those $25,000. He could only hold 25 because Ms. Quintanilla had already pulled the other money, so he wouldn't be able to. That's the reason. So what do? We go to the probate court because now we had letters testamentary and filed over there. So this exact case, exact issue, everything is right now in the probate court.
Okay, so then let me, one thing that I have not been able to clarify for myself, let me clarify this. Okay. So when did the divorce occurred in 2012?
I believe it was 2012, Judge.
Okay. And when was that? And do you recall the date that the divorce decree was signed?
I believe it was 2012. And he started putting money about 2 years later in the account.
Okay, but did that account exist at the time that they got divorced?
Yes, and each got their accounts and controlled them.
So the account existed at the time they divorced.
Correct.
And then and so he stayed with that account in the
Correct.
divorce decree. Okay.
It was not specific, Judge. It says whoever has control. But it's very important to note that she never did anything. She never put a penny in. She never pulled a penny out because it wasn't hers after the divorce.
Okay, but so he stayed with the account and the divorce decree because he was the sole owner?
No, both of them were there at that time.
Okay, but then was it assigned in the decree to him, or how did he stay with control of that account after the divorce?
Whoever had control of the account would keep it. That's the way it was.
So then the decedent stayed with control of that account.
Correct.
Okay, Mr. Molina shaking his head no. Mr. Molina, what is your position?
Here's the problem, Judge. First of all, with all due respect, all this line of questioning is irrelevant to the basic point that this is a payable on death account.
No, I understand. I'm just trying, I understand what you're saying, but I need this clarification for my thought process. Okay, so go ahead.
And again, I apologize for interrupting you. Here's the problem, right? It all boils down to poor drafting. When the divorce decree was entered into, it's like 99 out of 100 family law decrees. It had boilerplate language. They didn't put an account number. They didn't put any specificity. All they really wanted to do was get these folks divorced. Now, then and now, her driver's license, her social has always been on the account. She has always been an account holder. And so this decree that Javier brings up was poorly drafted if the intent was to make him the sole owner. Because typically what happens in family law cases is you list the account number and you take the person out. That didn't happen. So they stayed with that account, driver's license, socials, the whole bit, then and now. Nothing was ever changed specifically in the decree. And moreover, again, if you read decrees, they all talk about sole possession and control. That's like boilerplate language everywhere. Well, guess what? It wasn't in his sole possession and control. I don't know why they did what they did. All I know is I can read the document.
Okay, when you say that her social security and her driver's license were attached to that account, who is the person that you're referring to?
Maria Fernanda Quintanilla, formerly known as Maria Fernanda de la Rosa.
Okay, so you're saying that Ms. Quintanilla's social security number and driver's license was attached to that account during the marriage and remained attached to that account after the marriage?
Correct.
Okay.
Correct.
And then, and I mean, and obviously that is who was listed as, who you're saying was listed as the payment upon death beneficiary.
Correct.
That's not correct,
And,
Judge.
okay, I know Mr. Villalobos doesn't agree with that, but that's what you're saying, correct?
Correct. Can I
Okay.
further explain real quick a basic point on that?
Okay, go ahead.
Okay, the reason why it's important is because banks around the world, around the nation, in the Valley, rely on it. And so they're not going to get into who loved who hated who, are you married or divorced? They just look at a payable on death document and they simply want to know who's listed. Why do you put a driver's license, state issued ID? Because not any Tom, Dick, and Harry can go up there and say, hey, I'm Maria Fernanda de la Rosa, now Quintanilla. That's why you put in a state issued ID. Number two, why do you put a social security number? The reason why you put a social security number, again, to further identify, but there's accounting, bookkeeping that has to happen. So once you have a state issued ID, once you have a social security number, the bank, management, president, clerk can identify who's next, who gets the payable on death proceeds. And that's exactly what happened, Judge.
Okay, Mr. Villalobos, did you want to add something?
Well, actually, even the bank lawyer already told us she is not the beneficiary. Okay, so that's very simple. So that's done. And the other part that is also done is when they admit that they are not the owners. They admit it in the Court of Appeals, they admit it in the probate court, and they admit it every time we've talked to them. So if they're not owners, because in the divorce, after the divorce, she never deposited one thing. She never pulled a thing. And we're talking about 12, 13, 14, 15, 16, 17, about 6, 7 years. She didn't even know she was there because that was not her account. It was not until 2 heirs that didn't take were angry and they told her, hey, your name might still be there. Now, if you look at my motion, it states in there, it is based on control. And we know that Mr. De La Rosa is the one who controlled that account always. He started putting money in there about 2 years later. It was not, actually, when they divorced, there was a few $1,000s in there, Later on is when he started putting money in there. She didn't even know about the account until the heirs that were kicked out went and told her. And she immediately went and was able to pull the money because the bank didn't know about the divorce. So that's exactly what happened. So now the very same thing that we have here, we have in the court, the probate court, and they also issued a TRO. So the probate court has a TRO for the rest of the money, which is 175 or 275, Judge. I can't even remember right now. Okay, so this court only has 25,000. So my suggestion, Judge, really, if the court wants to just halt, is let the probate court go and hold this, and then we'll figure it out. But if the court rules something here that's contrary to what they want or we want, we're just messing things up. And now here we go again, because there's exactly two same things. And these issues, payable upon death beneficiary is something that they have over there, and owner is something they have over there in the probate court. Exactly the same thing, except over there, they have a lot more, and you have that issue. In other words, Judge, it's not your fight.
Anyone else?
And I'm sorry, I just want to add to make clear that these are non-probate assets. And so this court is the one who really needs to be deciding that. Also, this business about, oh, you admitted about not ownership. I mean, that's a bunch of nonsense. We took that as saying, even if you argue that she wasn't an owner, Miss Quintanilla was the one who was entitled to the money under the payable at death terms. So I think in terms of judicial economy and trying to get this matter over, it's best if this court retains the case and makes a decision based on the motions that are before it.
Okay, and if the judge were to decide on that, whatever the court rules, there's so many issues that it's not going to get rid of it, Judge. And that's why I'm suggesting send it over to where it really belongs. And I don't think the probate court would be ruling on something that's not probatable. So I asked the court to take a look at my motion. I think it is addressed there.
Okay. So I'm going to retain jurisdiction over this matter, and so we can continue with the rest of. Do you want to start with the motion for summary judgment that you filed in December?
Yeah, that would be appropriate, and Mr. Molina will address that.
Okay, Mr. Molina, you may proceed.
Okay, Judge, our motion for summary judgment, the reason why we're pushing it is because in my mind, legally, we see this as a simple case. Let me give you a bit of a factual background to this case. The De La Rosas, as I mentioned before, met when Mr. De La Rosa was the general manager of H&H Meats in Mercedes. That's a business that was founded in the 1950s by the former congressman's family, their parents. And so Ruben Hinojosa, Liborio Hinojosa, very astute individuals hired as general manager Ray De La Rosa, the decedent. And at this point in time is when they met. They had some tragedy in their lives, deaths of spouses. Ultimately, they married for the first time, and for a very long period of time had a very wonderful, like a lot of other people, blended family. They divorced the first time, then they got back together again, and they divorced the second time, as Mr. Javier Villalobos mentioned, in year 12. But at all points in time, they remained in contact, and they try not to let the adult kids get in the way of the relationship, but unfortunately, it did. And so one of the things that's very, very important, Judge, is when you look at the payable on death cases, you're going to run into a few important cases. One of them has to do with Punts versus Wilson. That's pretty much directly on point. And please stop me, Judge, if I'm rambling on. Are you okay? Can you hear me?
Yes, I can hear you. No, continue. If I need to, I'll stop you. Don't worry.
Okay.
I'll be honest, I have it on mute because I'm having issues with my dog.
Oh, sorry.
And she's barking and barking. So I don't know if something popped up out there. So that's why I have it on mute. No, I'm paying attention. Don't worry.
Okay. Punts versus Wilson on payable on death cases. Why is that case important to this case? Punts involved a friend who didn't have kids or a spouse, so two male friends, and he had worked at a refinery in I believe the Corpus Christi area, and so he wanted to give his sizable credit union account to his friends, and so he part of the estate went to one friend, and another one went via payable on death. So in that case, the specific issue that they argued was, hey, look, we want extrinsic evidence, parole evidence, to show that you really didn't know what you were doing when you gave me the credit union account, and we want to just present that evidence into court. The appellate's court, I believe, rightly said, look, we want to keep things simple. This is a payable on death. Unless there's extreme cases, we pretty much want commerce to continue. We want banks to do what they do. We want to help folks make their lives simple. So they didn't allow any parole evidence, obviously any extrinsic evidence to come into play to change the intent of the decedent. So that's the Punts versus Wilson case. And again, it's right on point, which is again why we're saying this is a simple case, and why we wanted to proceed with the judge looking at this and saying, okay, what does the payable on death document say? And it's there in the document, but basically, on the death of an individual owner, ownership passes to one or more beneficiaries or to one or more owners during their lifetime, and on the death of all owners to one or more beneficiaries. Okay, let's stop there, Judge. What does that mean as a practical matter? The current bank, formerly known as BBVA Compass, now known as PNC, is a global bank, probably one of the largest banks in the world now. And they're a multi-billion dollar company. This is their document, not mine. And so when Maria Fernanda Quintanilla went to get her money, and Javier is right, one of the heirs, I believe, not heirs because she didn't get anything, Belinda said, hey, go get your money. We had a meeting at the lawyer's office, and I believe you were entitled to it. So she went, and she presented her state-issued ID, she presented her social security number, and collected her money. That's just the way it works. It's a basic contract case, no different. If I, for whatever reason, want to leave a $50,000 life insurance policy and I pay the premiums to you or Keith or Christina or Javier, you don't have to put any money in. I just have to be lucid, and I have to know what I'm doing. And when I die, the money goes to whomever I leave designated. That's just basic contract stuff, non-probate assets. And so when you look at why we're seeing this as a summary judgment case, is because I think it fits the bigger narrative which is you want folks to have a sense of finality. You don't want these things to be litigated, and you want to try to keep it as simple as possible. And in this particular case, although the verbiage is maybe confusing to non-lawyers, it's pretty basic. The beneficiary was Max, and Max was Ray's son, not Maria. No doubt about that. But what I think Javier is being disingenuous about is the protocol. In other words, the way that Max would have ended up with it is if they both would have died at the same time. Let's assume they had been together in Florida and were leaving a motel room, and a big truck runs over both of them. Then guess who would be the beneficiary, right? Max. But while one person is still alive, in this case, Maria Fernanda Quintanilla, it just goes to her. There's no requirement that you've got to pony up money, although Javier admitted that she had ponied up, I guess, $20,000 at the beginning of it. You don't have to keep putting money in. That's the beauty of it. And so, Judge, that's why we see this as a very simple payable on death case. The case law supports it. And you're only going to find cases that are different than this, like the Minton case, when it has nothing to do with anything other than duress or real fraud or real undue influence. But here was a loving, caring relationship. She wasn't a gold digger. She wasn't a healthcare provider, caretaker. She was just a person who happened to know Ray since the Selena Quintanilla era.
Okay,
That's it, Judge, in a nutshell, my summary judgment.
okay.
Judge,
And your response, Mr. Villalobos?
I guess I don't know where there's no genuine issue of material fact. I don't know where they're trying to hit it. But anyway, I guess I'll just try to, based on what I think they're doing. Anyway, I've already told this court, and so has Ms. Cunningham, this is not a POD case. She's not the payable upon death beneficiary. And based on the divorce, based on the control, based on all that she never did anything, and they have judicially admitted she was not an owner. So if she's not an owner and she's not a POD beneficiary, she shouldn't take. Now, if there's issues regarding if she's an owner or not, then there's a genuine issue of material fact. So I'm asking this court to deny it.
Okay, so I do have your response on file to that, and I don't see Ms. Cunningham, I guess since it wasn't addressed to you, you don't have any arguments for this, is that correct?
No, Your Honor, we're not taking, the bank's BBVA is not taking a position as to who's the owner. We've been trying to serve all the potential heirs so that we could interplead the funds, but we have had no luck serving Raimundo or Ray de la Rosa at multiple addresses.
Okay,
Well, I can help you with Ray. Oh no, Max is the one I have. I'm sorry.
okay, so then, and Mr. Molino, and as to your summary judgment motion that you filed in July?
I believe so, Judge. The first one.
No,
No, this was your December summary judgment motion. So you all filed one in July. It's a second motion for summary judgment
Correct.
that I have filed on July 22nd. So are you going, do you want to elaborate on those, on your position on that one?
Okay, Judge, it has long been established, right, that a litigant who wrongfully obtains injunctive relief against another is liable for damages caused by the injustice. In this case, what we're saying via summary judgment is that at a minimal, we should recover the bond, which was, I believe, $1,000. And because of the Court of Appeals ruling in our favor, we feel that for a year now, Mr. Villalobos's client has basically not dealt with us in good faith. And we also feel that that if the court takes, which I'm asking the court to take judicial notice of this file, that it's just wrong what he did from the very first hearing with Judge Rudy Gonzalez, where he basically said he was going to file criminal charges against Maria Fernanda Quintanilla. And obviously that didn't happen. And even most recently to now, where he's asked for extensions and extensions because he's going to do quick discovery, or he's gonna need time to do responses. And we've tried to work with him, but obviously that hasn't happened. So in essence, that's the whole point of the second motion for summary judgment. It's to get folks to say, hey, if you're going to file these injunction TROs, you better be right. Whether it's a family law case or a bank case or anything else, because you're impacting in the former families and in the latter commerce. So that's the second motion for summary judgment, Judge.
Okay, Mr. Villalobos, any response?
Certainly, Judge, and actually we were right. The court granted our motion. And then the Court of Appeals, we didn't answer because even though he granted it, he allowed argument only, not evidence. So we had no issue. We knew at the very end that I wasn't going to waste anybody's time in filing something there, because at the end that was not going to succeed. But just like in the probate court, we were correct. That one was granted and they appealed to, and that one I feel very confident in the Court of Appeals, it's going to stand, but it hasn't come back. So when they say, it amazes me when they say that, oh, they lost. We didn't lose. It was granted. And that's why we did the other one, the 275,000. So whenever they're saying that we lost, we didn't lose, Judge. As a matter of fact, we're still here. Those 25,000 should be taken care of, and the other 275 in the other court. So he's incorrect about that too.
Okay.
Judge, can I respond to that just real quickly? First of all, apparently Mr. Villalobos did not read the Court of Appeals opinion. The Court of Appeals came back and said that the injunction was void. And so it was just, I mean, void means void. It's no good, it's improper, and it wasn't based on the lack of evidence. It was based on some other issues that Mr. Villalobos and his client were directly responsible for. And again, Judge Gonzalez did not preclude anybody from putting on testimony. So that was not an issue. Secondly, Mr. Villalobos did not, he came back in, I'm going to say it's, August, last time this was set for a hearing. And he says, I need discovery. I need time. I'm going to prepare this whiz bang, terrific response to demonstrate that there's a fact issue. Well, we're here 45 days later, and there has not been a response filed. All we have is the uncontradicted evidence from the Court of Appeals and from the defendant saying that this was a wrongful injunction and that they shouldn't have done it in the first place. And it's undisputed at this point that that's true. And so we're requesting summary judgment on our malicious prosecution and abusive of process causes of action.
Okay, where is the Court of Appeals opinion? Was that filed by any chance?
Your Honor, the Court of Appeals opinion should be in the court's record, and it's, I'm going to say July 21st, July 22nd is when it was filed, and it's also filed as an exhibit to the second motion for summary judgment.
Okay. I thought I had seen it as a separate filing, but I knew I saw it somewhere. There it is. Okay. It's the exhibit A. Okay. On July 22nd. Okay. All right, anything else on the summary judgment motions?
No, Judge, it's pretty much said that we disagree what the courts did was proper. They just did not allow us to present evidence. It was during one of these in the very beginning of the COVID situations. So it was based on argument. So which is the reason that we didn't say, we pretty much said, okay, let the Court of Appeals do what they need to do and bring it back, which we knew it was going to happen. The probate court, though, it's pending. That's going to be totally different because evidence was presented and the probate court did grant the motion.
Okay, and on the motion for sanctions?
Oh, Judge, I don't think it's going to be sanctioned.
Excuse me, Mr. Villalobos, that's our motion, and then you can respond to it.
Go ahead, Mr. Jackson.
Okay. Did you want to handle this one, Juan, or did you want me to do it?
Well, go ahead. Go ahead.
Okay. At the conclusion of the hearing in front of Judge Gonzalez, Mr. Villalobos points his finger and starts screaming through the Zoom meeting that he's going to be filing criminal charges against our client. And the whole purpose was to be intimidating her, to try to get her scared and upset. And at the time that he did that, he had not even read the POD provisions, which provided that she gets the money. And there's specific disciplinary rules that say you can't do that. You can't threaten criminal proceedings against a litigant if you're an attorney. It's barred, and that if it goes to the grievance committee, we've cited cases in the motion where attorneys have been sanctioned and disbarred for that precise type of conduct. And so it's Mr. Villalobos. It was just a flat out violation of the disciplinary rules. And of course, he's, to this day, he's unwilling to acknowledge that he did anything improper. But it was improper according to the state bar. So we're requesting sanctions for that particular conduct. Of course, the sanctions are going to be within the court's discretion, but we need to try to be professional on these things. And in trying to intimidate witnesses through claiming that you're going to go to the DA and file criminal proceedings is not how you act professionally.
Okay,
May I respond, Judge?
Yes, sir. Go ahead.
Certainly. Let me just get rid of this real quick. Okay, Judge. Actually, this is the way it went. I know exactly that I can't threaten people, and I didn't. What I told them was that my client, Susie, had filed criminal charges. Not that she had already done, because she didn't know what was going on. When she found out that the money had been pulled out, she went and filed charges. That's it. And I wasn't going to threaten anybody. It had already been done. I informed them. Now, once we found out about all the contracts and all that stuff going on, that there's a dispute, okay, here you go. The DA can or not take it. I don't think they will, because it's a contractual thing or a dispute regarding a contractual matter. But the issue of be threatening, that is incorrect. I asked the court, look at the transcript. Very simple. She had already gone to the police and she filed charges. I wasn't threatening anybody.
Your Honor, that's a wonderful display of ex post facto history, because that's not what happened. He said he was going to be filing charges against Ms. Quintanilla. It was clear as day. And he's now trying to backtrack on that, saying, oh, it was my client and she had done it before. And no, that's not what happened. What happened was he did it as an intimidation tactic. And he didn't, the fact is, again, he hasn't even filed a response to the motion saying what he's claiming now. This is the first time he's presented it. You know, that
Judge-
kind of behavior is improper. But even if you say it, what's the point of even saying that, Your Honor, in the course of let's say he's right. What's the point of even saying that in the course of the proceeding? He didn't have
Judge,
a
if he's so-
purpose for that.
sorry. If he's so concerned, he can file something with the state bar.
Okay,
I'd be
so
glad to respond.
if nothing else on that, you have the motion for costs, Mr. Leipzig?
Yes.
Go ahead.
Okay, this has been pending since December of last year. And every time we come up with a hearing, it gets continued. I think this is the 6th or 7th time that this matter has been set. And it's always Mr. Villalobos saying, I want to do discovery, or I want to do discovery, or I want to do discovery. Well, we're here in October and he hasn't done discovery. And he's saying, well, I want to take your client's deposition. He hasn't filed a deposition notice. And this could have been resolved, should have been resolved in May at the earliest, or excuse me, May at the latest, but it should have been dissolved in January when the initial motion, first motion for summary judgment was initially set. And he keeps on requesting with these incessant requests for delays and continuous delays. And then the last time we get up, he asked for a delay to file a response to the motion for summary judgment, and then he never did it. And at some point, Your Honor, and it's costing defendants time, it's costing the bank time that we're spinning our wheels necessarily. And to prevent things like that, you can file a motion for cost. And he should, it's like, if he's deliberately delaying things, and for unjustifiably, he should be liable for the costs associated with all these delays, for us having to go back and learn things and redo and re-prepare again and again and again and again and again. And so that's the gist of our motion for costs, Your Honor.
Okay, and who, is anyone else joining you in that motion? I don't know, is the bank joining you in that motion, or?
Your Honor, the bank's not going to take a position either way on the
Okay.
motion.
All right. Okay, Mr. Villalobos, did you want to respond?
No, Judge, it's pretty much, we keep on saying, and the reason it's very difficult to keep on pushing this case is because we know that it belongs in the probate court. Whatever we do at the very end, the 275 is over there. We're messing around with 25,000 here. So whatever happens here, ultimately, the big one's in the probate court. So, and when it comes to deposition, Judge, I don't want to, unless we have an agreement to do it, I'd love to do it, but every time we call, they never respond. But if they agree to do it, we can do it tomorrow.
Okay, so y'all have been having issues with getting deposition
Mr.
dates?
Lifesay and I have the worst communication ever, Judge, not just in this case, in every single case we've ever had together. And he can tell you the same thing.
Okay, I will agree that we've had problems in terms of getting documents, but what Mr. Villalobos said about requesting deposition is false. That never happened. I've never received a phone call from him saying, hey, dude, when can we set up the depositions here? I want to take your client's deposition. And if he's got problems with me and getting notice, Mr. Molina, who's really the client contact, he's free to call him, but that never, ever happened. And if that he never asked for a deposition, he never even tried to answer discovery. Furthermore, Your Honor, we've requested disclosures from them and they haven't even answered them. There are no intent to conduct any discovery in this matter at all.
And Judge, and we can take a look at that real quick because disclosure should have been answered. But here we go. We always have this issue with Mr. Life say, I don't get his stuff, he doesn't get mine for whatever reason. But if for whatever reason, and this is totally separate, but if it hasn't been answered, I can answer that by tomorrow. I don't care. That's something that, not that I don't care, it's just, I didn't know that. But I don't know, that's a very simple one. Disclosure, I can do in 5 minutes, even though it has nothing to do with this.
Judge, in our reply to the motion, to the first motion for summary judgment, which was in March, we point out the failure to file answers for requests for disclosures. So he's known in March, he's known in April, May, June, July, August, September. That's 7 months. He hasn't done anything in 7 months. And now, after the hearing has been held, he wants to file answers. I mean, this is, again, classic delay tactics that he's just trying to postpone this matter and delay a resolution.
Well, Judge, it's not a delay, but sometimes he files so much stuff that it even confuses my office. I'm sure his office is confused himself. And we have several cases together, and that's one of the issues we have, and we've always had, me and his office. It's not the first time. We have in County Court 5, we never get each other's stuff. And I can check, and if I haven't done it, I can quickly do it, even though this is not a motion to compel. But that's very simple, the disclosure. And
Well,
maybe I already did. That's what I'm telling the court.
Okay, so I know we're not here on any type of discovery issues, so I mean, that's just gonna be completely on you all, whether or not maybe when you get your file, Mr. Villalobos, you can go over it and see if you have anything that's outstanding. And I mean, if you choose to, you can go ahead and take care of that. But Ms. Cunningham, and you can answer this question if you feel comfortable, because I know you kind of, it's Mr. Villalobos stated that you're in agreement that this is not a payment upon death account. Is that the bank's position?
No, Your Honor.
Okay,
On the document itself, in this section of the signature card, the box next to POD has an X in it indicating it is a payable on death account.
And the beneficiary,
The payable on death provisions reads, on the death of an individual owner, comma, ownership passes to one or more beneficiaries or to one or more owners during their lifetime. And on the death of all owners to one or more beneficiaries. And then it says, if the owner wishes the bank to omit POD designation from the account, title, initial here, he did not initial, it's blank. And so it is a POD account, but based on that provision, there is a beneficiary, but that beneficiary is Maximino de la Rosa. But as I just read that provision, the PO death provision to you, when the beneficiary takes ownership, is not just upon the death of one account holder.
okay? Unless there's a divorce and control and everything. And that's what we have.
I'm just reading the document.
Correct.
Yeah.
I agree.
okay. Yeah, I just needed that clarification, and she's just reading the document, and obviously
Yes.
each of you will have your own positions to take. So now, where is that as an exhibit? Because you all have several things filed, and I came across that, but now I don't know where did you all put that as an exhibit? I know it says an exhibit on one of these documents. You're on mute, Ms. Cunningham.
I just realized that. It
Okay.
is an exhibit to defendant's motion for summary judgment that was filed in December. And it's exhibit E. I'm sorry, exhibit B is in boy on that motion.
Okay, the one from December 8th.
Yes, ma'am. Or yes, Your Honor, sorry.
Okay, I have it. Okay. Yes, because I know I read it, but then I lose it because it's on the, I had to read your motions to get ready for this afternoon, and I knew I read it as an exhibit, but I couldn't remember anymore which one it was attached to. I don't have a photographic memory. I just have a good memory where I can generally state. Okay, so I will take judicial notice of all the documents in the court's file, and I've taken obviously notice of all the arguments that have been placed on the record. And I do have the motions that were pending for clarification was the motion to transfer, the December motion for summary judgment, the July motion for summary judgment, the motion for sanctions that was filed in December, and the motion for cost that was also filed under the title of bill of cost, I believe. So I have all of those. I am taking all of that under advisement. I am going to, I just need to make sure that you all have your orders on file, whatever order you want me, even if they're competing orders that you want for me to look at, because I do look at all orders. If my ruling is not in line with your orders, I will create my own order, okay? And I will set myself a tickler for October the 29th to issue a ruling, and it may come sooner than that. Okay?
Thank you, Your Honor.
Thank you, Your Honor.
So,
Thank you.
I'll take, you all already have everything on file and everything that's attached as exhibits. And so I've already taken a couple of reads at it, but I'll read it again and issue a ruling. Make sure those orders are on file though. Okay, ladies and gentlemen?
Thank you.
Yes.
Thank
All
you.
right.
Thank you.
Thank you. We're now off the record. Y'all have a good day.
Thank you.
My